Today, we're going to be talking about the Battle of New York. Now, I'm not talking about going back in time and to the American Revolution, although many of the ideas that will be discussed in this rant are revolutionary and do, in fact, date from the time of the birth of our constitutional republic. But I'm talking about the battle that's being waged today in a courtroom in Manhattan. The courtroom of a district judge named Alvin Hellerstein. He sits on the bench of the Southern District of New York, and Hellerstein is currently overseeing the trial, or at least preparatory arguments in anticipation of a trial of Nicolas Maduro and his wife, who were illegally abducted by American Special Operations Forces earlier this week. Alvin Hellerstein is 92 years old. He's been around for a while. I think in 1989 he was appointed to the bench by Bill Clinton. Interesting character. He's been overseeing the Maduro case since the 2020 indictment. He's the one who set forth the indictment, heard the grand jury argument, and and he's the guy who created the paperwork that created the justification that was used by the Trump administration to take Maduro into custody. But, the indictment doesn't give carte blanche for the United States to forego constitutional due process.
Scott Ritter says the real battle isn't military, it's legal, and it's happening in a Manhattan courtroom. He explains that an old indictment was used to justify Maduro's capture, but that due process still applies under the U.S. Constitution. Ritter highlights Judge Alvin Hellerstein, who has previously ruled against the government when rights were violated. His point is that this case could test whether America still follows its own laws, and the long gap between court dates signals a drawn-out legal fight, not a fast political victory.
And Hellerstein is on record in the past. Just last year, he opposed a Trump administration decision to deport Venezuelan illegal immigrants, citing that they had been denied their due process. So legal processes do matter. And so this will be interesting to see what Hellerstein does. At this juncture, he's not in the business of hearing arguments. He took the plea, a not guilty plea from Maduro and his wife, and has set the next court date to be March 16th. And I think we can see by the delay between court dates that this is going to be a long, drawn-out affair, as American justice normally is. Now, why am I calling this the Battle of New York? Look, plain and simple, what's happening here today isn't just an assault on, the rule of law. It's an assault on the very fabric of the identity of the United States of America.
Scott Ritter says this case matters because due process still counts, even now. He points out that Judge Alvin Hellerstein has previously ruled against the Trump administration when Venezuelans were denied their legal rights, showing the judge takes the Constitution seriously. Ritter explains that the slow court schedule signals a long legal fight, not a quick show trial. Calling it the Battle of New York, he argues this isn't just about Maduro. It's a test of America's identity and commitment to the rule of law itself.
We have a situation where the sitting president of the United States, in absolute disregard for both the Constitution and international law, has taken into custody the sovereign leader of a sovereign state. This is a straight-up violation of the Charter of the United Nations. Now, people will say, well, what does the United Nations matter? I mean, Marco Rubio, our Secretary of State, certainly doesn't believe that the United Nations matters, but it does. You see, when we look into the Constitution of the United States, we note that the President of the United States has authority to enter into treaties, and that when these treaties are ratified by 2/3 of the United States Senate, they take on the effect of law. And subsequent decisions by the Supreme Court of the United States, one in, I believe, 1824, the other in 1886 or so, basically say that treaties are the supreme law of the land. When we When we enter into a treaty relationship, we sign it, the president signs a document and the Senate ratifies it, it becomes the law of the land, constitutionally enforceable.
Scott Ritter says the U.S. president crossed a serious legal line by seizing the leader of another sovereign country. He argues this violates international law and the UN Charter, which the U.S. is legally bound to follow. Ritter explains that treaties approved by the Senate aren't optional. They are part of U.S. law under the Constitution. His core point: ignoring the UN isn't just foreign policy arrogance. It's a constitutional violation that undermines America's own legal foundation.
And so when we have Marco Rubio and Donald Trump and others saying international law doesn't matter, when we have American citizens say international law doesn't matter, what you're saying is the U.S. Constitution doesn't matter. The rule of law doesn't matter. And now we have a problem because this is a constitutional republic, and the only legitimacy it has as a sovereign nation is its constitution. So the moment you say the Constitution doesn't matter is the moment you say that the United States of America no longer exists as a constitutional republic. And this is the problem. A significant number of Americans seem to believe that this government, this president, is above the law. He can do anything he wants. The Constitution is an impediment. It's not, ironclad law. It's an obstacle that needs to be navigated around.
Scott Ritter warns that dismissing international law is the same as discarding the U.S. Constitution. He explains that America's legitimacy as a nation comes from its Constitution, not from raw power. If leaders or citizens believe the president is above the law, then the constitutional republic stops functioning. Ritter's message is blunt. Treating the Constitution as an obstacle instead of binding law is dangerous, and it puts the very existence of the United States as a lawful nation at risk.
This is extremely problematic. Now, the Constitution, has put in protections against presidents going out of control. We have a system of government that has checks and balances, 3 separate but equal branches of government. So here we have an executive that's clearly off the rails, doing whatever it wants, in total violation of international law and total abrogation of its constitutional duties and responsibilities. But we have a Congress that should be able to step in and do something, but they're not. Congress is asleep at the wheel. Congress has totally allowed itself to be castrated when it comes to war powers, allowing this president to do anything he wants and not doing anything to hold him to account. And Congress is silent on the issue of treaties. You see, again, not to get too much into the weeds here, but when we sign a treaty, it is the law of the land.
Scott Ritter says the system meant to stop a runaway president is failing. He argues the executive branch is ignoring both international law and the Constitution, while Congress refuses to act. Instead of using its war powers and oversight authority, Congress has backed away and let the president do whatever he wants. Ritter's warning is clear. When Congress stays silent, especially on treaties which are legally binding, the checks and balances collapse and the Constitution becomes meaningless.
Now, the president can decide if the United States doesn't want to adhere to a treaty, and he does this through bilateral negotiations or discussions with the nations involved. And if it comes down to it, nations can find one another in breach of treaty obligations, and this can lead to war. But that's not what's happening here. The president just ignored it. The nation at stake is too weak to do anything about it. And now he's taken a leader to court. But the court has no jurisdiction. You see, the treaty is the law. And unless Congress enacts legislation that modifies, repeals, or otherwise, puts conditions on this treaty law, the law is the supreme law of the land, and the United Nations Charter prohibits the United States from going forth and seizing Nicolas Maduro, the legitimate president of Venezuela, and bringing him to the United States. We have no jurisdiction over this matter. No court can see this case.
Scott Ritter says the president didn't legally exit or challenge the treaty. He simply ignored it. He argues that treaties are binding U.S. law unless Congress changes them, and the UN Charter clearly forbids seizing a foreign head of state. Because Venezuela is too weak to respond, the U.S. acted anyway. Ritter's key point: American courts have no legal jurisdiction here, and putting Maduro on trial is unconstitutional. This isn't law enforcement, it's power being used outside the law.
No court can see this case because Congress has taken no action to modify the United Nations Charter in a manner that allows Trump to do this. So now it comes down to the court. You see, two branches of government, the legislative and the executive, have punted on their responsibilities, their constitutional duties and obligations. And it comes down to a 92-year-old, district judge, Alvin Hellerstein, to decide whether or not this constitutional republic will survive. Because I'm here to tell you right now, if this president, who has 3 more years to serve, gets away with this absolute violation of the law, of the Constitution, if the executive branch can act as a dictatorship with no checks and balances from either the legislative branch or the judicial branch, then this is over for America. We may call ourselves the United States of America. The flag we fly may still be the stars and bars, but it's over. Which brings me to the revolution. And Thomas Jefferson, in 1987, he wrote a letter to William Stevenson, a New York lawmaker, a representative of the state of New York, United States Congress, and he talked about, the birth of the United States.
Scott Ritter is identifying a total systemic failure here, and his argument is terrifyingly simple. He claims that both Congress and the White House have completely abandoned their duties regarding the UN Charter. Instead of following the law, he argues they have punted their responsibilities, refusing to check the president's power. Because the political branches bailed out, Ritter points out that the survival of the constitutional republic now rests on the shoulders of just one man, 92-year-old Judge Alvin Hellerstein. He frames this as a desperate last stand for the legal system.
He said, look, it's been, we've created a nation of 13 states that have been together for 11 years based upon a single act of rebellion. But he said, you can't expect the people to always be on the ball. Even during the rebellion, the people weren't as informed as they should have been about many issues. And as a result, when you have a people that are not actively engaged in the processes of governance, then the government will begin to behave in a tyrannical fashion. And then it may be time for the people to rise up again. The tree of liberty must be washed in the blood of patriots and tyrants, Thomas Jefferson said. It is the manure of life. The United States has been around for 250 years. On July 4th, we'll celebrate our 250th year of independence.
Scott Ritter digs into history to explain why he thinks this collapse is happening. He argues that public apathy creates dictatorships. When citizens stop paying attention to how they are governed, he says the government naturally starts acting like a tyrant. To drive this home, he quotes Thomas Jefferson's famous line about the tree of liberty needing to be refreshed with the blood of patriots and tyrants. Ritter is characterizing rebellion not just as a one-time event, but as a necessary cycle to keep freedom alive. He ends with a dark contrast. As we approach the 250th anniversary of the United States, Ritter suggests we aren't just celebrating the past, we are overdue for that next cycle of resistance to save the nation.
But if Donald Trump gets away with what he has, this is literally the last year we can say we function as a constitutional republic. It is the end of the United States. And then we, the people, have a choice to make. Do we become simply a Roman mob, sitting in a Colosseum, waiting for the Emperor Caligula to appease whatever base desires we have through violence, through gluttony, through sex? Or do we act as the independent people we are, a people founded in the notion of the rule of law, people who believe in justice, people who believe in a better way of life, people who will not stand the actions of tyrants? Choice will be ours to make in the near future. I hope we don't have to make it. I hope Alvin Hellerstein wins the Battle of New York, and I hope the constitutional republic is restored.
Scott Ritter is issuing a final warning. He argues that because Congress failed to do its job, the survival of the republic now rests entirely on one judge's ruling in New York. If the courts fail to stop this, Ritter claims the American experiment ends this year. We stop being a constitutional republic and become a Roman mob distracted by a dictator. His bottom line is brutal. Either the legal system saves the Constitution now, or the people will be forced to choose between total submission or a Jeffersonian revolution.